program today, Redistricting and Gerrymandering, the Good, the Bad, and the Ugly. Our program should last about 90 minutes today, and all questions and answers will be done at the end of the program. And I would ask that you take a look at your computer, look at the chat function, and that all questions be put in the chat function. We will find the questions and get them over to the panel at this point in time. With that, I would just like to not only welcome everyone for showing up, but let you know that all questions are welcome. And I would like to introduce you very briefly to our panel that will be speaking today. Our first panelist is Seth Kramer, and he is the Grinnell Professor of Law at the University of Pennsylvania Carey Law School, and he is an expert in constitutional law and public interest law firms, and frequently law firms frequently seek him out for his expertise. Our second panelist is Benjamin Geffen, and he is a staff attorney at the Public Interest Law Center. He was counsel of record in the challenge to the Pennsylvania gerrymandering congressional district case that resulted in the new map in 2018. Our third panelist is Carrie McClellan, and she is an assistant counsel at the NAACP Legal Defense Fund. She was counsel in the case challenging Pennsylvania's system of prison gerrymandering. Our next panelist will be Rory Kramer, is an associate professor, Department of Sociology and Criminology at Villanova University. He is the co-author of an article and documented the effects of Pennsylvania's prison gerrymandering. And finally, we have Deborah Gross, is the president and CEO of Pennsylvania for Modern Courts. PMC has been an active opponent of a proposed state constitutional amendment which would gerrymander appellate courts and elections. I know that is very quick for all of them, and their bios are contained in materials enclosed if you want to read a little bit more. But with that, I'm going to turn it over now to Seth Kramer and allow him to begin his presentation. Seth?
Thanks very much, Wes. So my assignment is to cover 2.5 centuries of constitutional law and history in 15 minutes. This will be hypersonic, and hopefully we can get through it. So for those of you who haven't encountered him, up on the PowerPoint here, you see Elbridge Gerry. Elbridge Gerry was the governor of Massachusetts. He was a Jeffersonian Republican, and he and his party wanted to arrange things so that the Federalists had as few seats in the state legislature as possible. As part of this, he arranged to have Essex South district look like this. The Federalist newspapers considered that to look like a salamander, and they captioned it the gerrymander. Over the years, it is turned into gerrymander. The general concept is arranging electoral districts in ways that minimize or maximize particular parties' electoral prospects. Now, Elbridge was also a delegate at the Constitutional Convention in 1787, and fond as he was of manipulating electoral schemes, he proposed that the Constitution should provide that the total number of representatives in new states should never exceed the total number of representatives in the original states, making sure the original states had a preponderance of votes in the House of Representatives. That was not passed. But let's take a quick look at what was passed. The original Constitution provides for the election of a House of Representatives chosen every second year by the people. Who can vote for a House of Representatives? Well, there is an expectation that each state has its own rules as to who can vote. And indeed, the rules differed from state to state. The rule, therefore, was that the electors for the House of Representatives in each state would be the same as the rules as to who could vote for the most numerous branch of the state legislature. There was debate where Jerry wanted to have the original states prevail. There was the small states worried they would be outvoted by the big states. The compromise was that the Senate would have 2 senators per state, but representatives would be apportioned according to the states according to their respective numbers. And at the time, the framers of the Constitution adopted the notorious 3/5 compromise, so that in evaluating how many representatives the state got, they would count at the whole number of free persons and 3/5 of, quote, all other persons, close quote, meaning slaves. Finally, in setting up the apportionment of representatives by population, the Constitution provided that every 10 years there would be an actual enumeration by Congress, what we now know as the census, of the number of individuals, free persons and all other persons in each state. So how are these elections to be held? Well, the Constitution says, once again, the states get to choose. States get to determine the time, place, and manner of holding elections, with the possibility of a congressional override. If something is sufficiently outrageous that Congress thinks that a different rule should be adopted regarding time, place, and manner of holding elections, Congress can make or alter the rules that the states initially set up. And finally, by way of background, the Constitution doesn't say much about the way the states are to elect their own governments. There's an expectation, though, there will be a legislature. There will be a legislature elected by the people of the state. But the furthest the Constitution goes is to say that the federal government guarantees to every state a, quote, Republican form of government. This is, to put it mildly, a capacious term. Republican forms of government were governments that were responsive to the people, the res publica. So what does Congress do under the Constitution? Up till the mid-19th century, almost nothing. Everything was in the states' hands, and the states adopted a variety of approaches. Some states had multi-member districts for Congress. Some states adopted their congresspeople at large on general tickets. Some states had single-member districts. In 1842, Congress adopted a requirement under its authority over time, place, and manners of elections, requiring that federal representatives be elected from contiguous single-member districts. After the Civil War, the people amended the Constitution to eliminate the 3/5 compromise. The allocation is now, the portion is now according to the whole number of persons in each state. And the right to vote is to be accorded to male inhabitants 21 years of age and older who were citizens, and the apportionment would be reduced if the states denied or abridged the right to vote to that group. Notice the excluded group, non-citizens, non-males, people under the age of 21, and those who were convicted of rebellion or crime. Over the course of the 19th century and early 20th century, Congress stepped up several times to tighten the rules. In 1872, Congress required that the districts from which Congress people were chosen would be as nearly as practicable have an equal number of inhabitants. So the same number of inhabitants in each district, the precursor of one person, one vote. In 1901, in addition to a requirement of contiguity, Congress imposed a requirement of compactness. And finally, in 1911, Congress imposed a maximum number of states. Up till then, Congress had expanded every time the population expanded, meaning that nobody ever lost seats. After 1911, Congress imposed a 435 seat maximum, which means now every census, states will have to either add or subtract seats depending on what their proportion of the total population is. Finally, after a disastrous encounter in 1920 with the experience of Congress being unable to reapportion in response to the 1920 census, in 1929, Congress adopted a set formula to allocate seats by virtue of the census that went into effect without congressional dickering. But in the process, it did not reenact any of the mandates about equal population contiguity or compactness. And in Wood versus Broom in 1932, the Supreme Court held that there was now no limit on the ways in which states could apportion their single member districts. Okay, so what does this then mean for the capacity of states to fix the outcomes of elections? Let's take a very simple example. Imagine a state which has 3 representatives and has a population that's 66% blue and 34% orange. The question is, assuming to make things very easy, that the orange people all live in this area, the blue people all live in this area, blue people vote for blue candidates, orange people vote for orange candidates, how does an electoral system allocate those seats? Well, one possibility is the electoral system, since the states have control over the franchise, could say that, under the original Constitution, could say only orange people can vote. Over the over the period after the Civil War, both the Constitution and the courts imposed some limitations on disenfranchisement. To make things simple, the 15th Amendment prohibits disenfranchisement on the basis of race, the 19th Amendment on account of sex, the 24th Amendment prohibits disenfranchisement for non-payment of taxes, and the 26th Amendment prohibits disenfranchisement by virtue of age over the age of 18 years of old. Congress also passes the Voting Rights Act in 1965, which imposes some limitations on efforts on imposition of a series of devices that have the intent and effect of disenfranchising on the basis of race, but don't actually say race. Literacy tests, constitutional interpretation tests, my favorite. Education tests, character tests are prohibited initially in southern states where there is a vast disenfranchisement, later nationwide. And finally, in 1966 and 69, the court adopts a requirement that exclusions from the opportunity to vote for people who are citizens and residents and of age must be justified by some sort of compelling state interest. That's the rule we have today, with some bells and whistles that we won't go into, but saying only orange people can vote is now off the table. But is there a way of making sure orange people still win? Answer, yes. What can you do? Well, first of all, you can say that for the 3 districts, we're going to cut things so that we have 2 districts that are all orange and 1 district that is all blue. What does that mean? It means you end up with 2 orange and 1 blue, despite the fact it's a 2-to-1 blue to orange majority. Over the next, over the late 20th, mid 20th century to late 20th century, the Supreme Court cuts off that opportunity. They impose a requirement of 1 person, 1 vote. So within the parameters of 1 person, 1 vote, what can a mischief maker do? Well, take a look at the screen now. 1 person, 1 vote in this setup. You can arrange things, if you draw the lines vertically, so that you have no orange votes. If you draw the lines horizontally, you have 1 orange vote. If you have three electors at large, you have no orange votes. And if you get a little creative, as in the lower left-hand corner, you can whack things up so that you have 2 orange electors and 1 blue elector, notwithstanding the fact that it's 2-to-1 majority of blue to orange. So that's a very, very simple version of it. As computer technology comes online, it becomes possible to do much more sophisticated types of gerrymandering. What we have on the left-hand corner is Pennsylvania's 7th district, which evolves from something that looks fairly mundane to ultimately something that is set up so that it looks like Goofy kicking Donald Duck. So what to do about that? One possibility is the courts can second guess it. And indeed, over the course of the 20th century, the courts in the where this mechanism is adopted to try to minimize minority participation, in fact, does intervene. In Gamillion against Lightfoot in the upper left-hand corner, we have the city of Tuskegee gerrymandered to exclude Tuskegee Institute from voting in the city. In other words, making the city electorate all white. Supreme Court in Gamillion against Lightfoot says, looking at this, it's practically a mathematical demonstration that this is fencing out blacks. It's unconstitutional. Likewise, later in the 20th century, the Supreme Court adopts the approach in cases called Shaw versus Reno and Bush versus Vera, of asking whether race is the predominant factor motivating a legislator's redistricting decision. So it strikes down a couple of districts in North Carolina designed actually to maximize African-American representation. One looks like a snake, one looks like a bug on a windshield. And Bush versus Vera, they invalidate a district in Texas drawn to minimize participation by Mexican Americans. So it's not impossible to second guess a determination of the legislature, depending on whether or not the legislature is clearly trying to minimize votes by, or to define votes by minorities. However, and here we're getting close on time, over the course of the 20th century, the Supreme Court, originally in Davis against Vandermeer in 1986, addressing the question of when political parties play the same games, 6 members of the court thought that there could be situations in which the court would invalidate a political gerrymander. 3 thought that there would be intractable difficulties in getting a rule trying to deal with political gerrymandering. Over the course of the 20th century, that 3 grew to 4, to 5, and ultimately in Rucho against Common Cause, Chief Justice Roberts writes for 5 members of the court in addressing a situation in North Carolina where David Lewis, pictured here, announces, I propose we draw maps that give a partisan advantage to 10 Democrats and 10 Republicans and 3 Democrats, because I do not believe it's possible to draw a map with 11 Republicans and 2 Democrats. Clearly, there is intent here, and clearly it was demonstrated at the trial court there was effect. But Chief Justice Roberts says it's not clear, it's impossible to determine exactly how much intent is required, because always people drawing boundaries are going to take politics into account, and there is no manageable criterion. So he acknowledges this is incompatible with democratic principles, but he won't intervene. Situation at the beginning of the 21st century, we have a 1-person, 1-vote rule. We have a requirement of redistricting every 10 years. There's some limitation on what gerrymandering can take place, but not a heck of a lot. Here's Cleveland and Akron connected by a long corridor in order to minimize Democratic votes in Ohio, because you can put all of the Democrats in this area of Ohio together and have them waste their votes. Response on the part of the Supreme Court, for those of you who are literary aficionados, Herman Melville's Bartleby the Scribner story. Bartleby, every time he's asked to do something, just says, I would prefer not to.
Seth, you were perfect. I couldn't have timed you better if I had jumped in and said you only had 30 seconds left to go.
Okay.
So now that Seth has given us the historical background and a little bit of the legal context, I'm going to now turn it over to Ben, so he can tell us a little bit about what's going on a little bit more on the modern side. Ben, the floor is yours, sir.
Thank you. Thanks for having me today. Thanks to everybody for coming. Again, I'm Ben Geffen from the Public Interest Law Center here in Philadelphia. And I want to talk about how this process works in Pennsylvania. So as Seth mentioned, every 10 years, to satisfy the one person, one vote rule, states must redraw their congressional and state legislative districts. And we are at the beginning of that process right now in Pennsylvania. There are, different states use different methods to draw their districts. And the way we do it in Pennsylvania is different for state legislative districts versus congressional districts. So for state legislative districts, there's a 5-member body called the Legislative Reapportionment Commission that draws the districts. It consists of the 2 Democratic leaders from the legislature, the House and the Senate leaders, and the 2 Republican leaders. The 4 of them are to select a 5th person to be the chair. Almost invariably, they deadlock. And indeed, that's what happened just a couple weeks ago, or last week. And when they deadlock, the state constitution, Article 2, Section 17, says that the Pennsylvania Supreme Court picks the 5th member. And that actually just happened. Pennsylvania Supreme Court just named Mark Nordenberg, former chancellor of Pitt, before that, the dean of Pitt Law, to be the chair. That news came out just yesterday. So it's going to be very interesting to see how that plays out. I want to talk about, and then the congressional districts are created by a simple legislative enactment. It's just a bill passes the state legislature, it's signed or vetoed by the governor, and that's how we get our congressional districts. Pennsylvania lost a seat in this census. And in fact, Pennsylvania has lost at least 1 seat in every census going back to 1920. In 1920, we had 36 seats in Congress, in the House. We've lost half of those. We're down to 18. And starting with the next election, we'll be down to 17. So that's another reason Pennsylvania must do a painful redrawing every decade. I want to talk about a little more about how the Legislative Reapportionment Commission and how the congressional districts work. And there are both procedural aspects and substantive aspects to it. I'm going to talk first about the procedural aspects, and that's because I'm being mindful of the quote from the late Congressman John Dingell, who said, "If I let you write the substance and you let me write the procedure, I'll screw you every time." And indeed, where the procedure lies is where the power lies. And so, and one way to illustrate that is what happened in Pennsylvania after the 1990 census. There was a member of the Senate named Frank Pecora who had angered leadership. I think he'd switched parties. Nobody was feeling very fond of him. And so the Legislative Reapportionment Commission ended up drawing him out of his district. He represented the 44th Senatorial District, which was in Allegheny County. And they redrew the map and they moved the 44th District to Chester County. This presented a predicament for Senator Pecora. Gamely, he went ahead and rented an apartment in Chester County and tried to run for office again there. Did not win. And, so the LRC process has often been dominated by these kinds of activities, by the caucuses punishing members who they don't like, rewarding members who are in their good graces, and so forth. So it is a very political process. It's also not quite the same game of musical chairs that we have with the Congress, because the number of seats doesn't change. We have 203 seats in the House, 50 in the Senate, and those numbers are both fixed. The process for how they are to do their work is laid out in the state constitution. Once again, Article 2, Section 17. And now that the 5th member has been selected, the next thing to happen is for the U.S. Census Bureau to release final census data for use in the redistricting process by the states. Because of COVID, this got somewhat delayed. They are going to release a tranche of data in mid-August and the final data by September 30th. And after that, the LRC will have 90 days in which to draw a new map for the state Senate and a new map for the state House. The LRC will hold a series of public meetings across the state where they will hear public comment. They will also accept public comment in writing. And one thing that everybody out here can do is to plan to make yourself heard by the LRC. And some of the big issues that are going to come up this year in this process include partisan gerrymandering, which I'm going to talk about in a bit, prison gerrymandering, which a panel after mine will be discussing, and a panelist after I will be discussing, and a few other issues that I'm going to get into momentarily. So the process for drawing LRC districts concludes with, so the next step is the filing by the LRC of this plan. But then after that, there is a process for people to challenge the plan. And it's a unique process. Under Article 2, Section 17, any aggrieved person can challenge the plan by filing an action directly in the Pennsylvania Supreme Court. So the Supreme Court exercises original jurisdiction over such challenges. They hear them on a highly expedited basis. Typically, they will consolidate all of the many challenges that are heard into a single case. And that is going to be happening probably in late 2021, depending on when exactly the LRC map comes out. And in previous cycles, there have always been challenges. It wasn't until 10 years ago that any challenge was successful. My colleague at the Public Interest Law Center, Michael Churchill, represented Amanda Holt, who was at the time a 29-year-old piano teacher from Allentown, Pennsylvania, who saw a very flawed map come out of the process, thought she could do it better, drew her own map. And the Supreme Court said, you know what, she's right. That is a better map. It proves that this map could have been better. And they threw out the original maps, sent them back to the LRC on remand to redraw. And after redrawing the maps with some improvement, but still some shortcomings, those are the maps that we use. Also, one thing to note is that because that process took a while, and because the LRC was late in releasing its final maps that time, Pennsylvania had to keep using the old maps for the 2012 state legislative elections, even though they probably violated the one person, one vote mandate. Nonetheless, that's how it happened. In the congressional process, it plays out very differently. So 10 years ago, remember, this is a regular bill that proceeds through the legislature and is signed by the governor. 10 years ago, the Republicans controlled the state Senate and the state House, and Tom Corbett, the Republican, was the governor. So this bill was passed on a completely one-sided basis. The Democrats were entirely excluded from the process of drafting the bill. It was sprung on them in late 2011 in the legislature. They saw it in the morning, and it was voted through the House by that same evening. Barely a week later, it passed through the Senate. No Democratic amendments were entertained, signed by the governor right away. And what came out of that process was a map, kind of like one of those orange and blue maps that Seth showed. It was drawn in a way that even though Pennsylvania is a purple state, very closely divided between Democrats and Republicans, the map was very carefully configured to ensure that Republicans would enjoy a 13-5 margin in every congressional election. And that worked in 2012 and 2014 and 2016, no matter the outcomes of elections statewide. Even in years when Democrats won a majority of the US House votes statewide, Republicans got that 13-5 advantage under that map. This is the map that the Public Interest Law Center challenged on behalf of the League of Women Voters and 18 individual voters back in 2017. And I'll talk about that case again in a moment. So what happens if the legislature and the governor are unable to reach a deal? And that's, a question that we may be facing in this state now that we have, again, divided control with the Republican-controlled legislature and a Democratic governor. The last time this happened in Pennsylvania was in 1990. There was an impasse. Pennsylvania had lost at least one seat, so using the old map was not really an option, not to mention the one person, one vote problems. So the Pennsylvania Supreme Court drew a new map itself. That case was Mello v. Mitchell. And so that's one possible outcome. And then after the 2010 map census and the new map that came out, and we challenged it, the Pennsylvania Supreme Court struck down the map, and I'll talk more about that case in a moment, but told the legislature and the governor, you have 3 weeks to come up with a new map. They were unable to reach agreement, and so the Supreme Court drew its own map in that case as well. So substantive provisions. These are found for the state legislative districts in Article 2, Section 16 of the state constitution. It requires that the state legislative districts be drawn to be compact, contiguous, and with equal population. And it also says, unless absolutely necessary, no county, city, township, ward, etc., shall be divided in forming either a senatorial or representative district. This was the provision that formed the basis for the suit brought by Amanda Holt. And it was, she was concerned because her neighborhood in the suburbs of Allentown was split in two. She didn't understand why this little area had to be divided across 2 districts. She played around with the numbers and was able to draw a map that did a much better job all over Pennsylvania of keeping local government units intact. And the Supreme Court said that provision that says, unless absolutely necessary, don't split local government units, really has teeth. And that the Legislative Reapportionment Commission can't just freely ignore that to draw a map that satisfies whatever other ends it prefers. And so that's one important provision. The Pennsylvania Constitution nowhere explicitly mentions congressional redistricting, neither process nor substance. It's just not in there. However, the Constitution of Pennsylvania does contain some protections of the right to vote, and that includes the clause known as the Free and Equal Elections Clause. That clause was the basis for the victory in the League of Women Voters case about Pennsylvania's congressional districts. And the court had also addressed this issue in Mello back in 1992, after the impasse failed to result in a legislatively drawn congressional map. And essentially what the Mello decision said is that those same standards from Article 2, Section 16, equipopulous, compact, contiguous, avoid splits, applied to congressional districts, and those were the neutral criteria that the Supreme Court used in 1992 to draw a congressional map. And the League of Women Voters decision in 2018, the Supreme Court affirmed that those are the appropriate neutral criteria to use. And it said that, but when it is demonstrated that in the creation of congressional districts, these neutral criteria have been subordinated in whole or in part to extraneous considerations, such as gerrymandering for unfair partisan political advantage, the congressional redistricting plan violates the Free and Equal Elections Clause. And so that was a groundbreaking decision. It was the first time in US history, actually, that a state Supreme Court had thrown out a statewide congressional map on partisan gerrymandering grounds. It became especially important. Seth mentioned that case Rucho versus the Rucho case of North Carolina from 2019, in which the Supreme Court said, I would prefer not to. The Supreme Court will no longer be entertaining cases, the US Supreme Court will no longer be entertaining cases alleging unconstitutional partisan gerrymanders. That leaves state Supreme Courts as probably the only venue for adjudicating these types of claims. And Pennsylvania Supreme Court, believe it or not, is the national leader on this. One other interesting thing to note is that the new map was a much fairer map. It doesn't have goofy kicking Donald Duck anymore. It has districts that are compact, they're contiguous, and it's a fair map in the sense that in a very purple state, it tends to result in 9 Republican and 9 Democratic seats. And it also opened up opportunities for participation by new members, including under the old map, we had 18 men and no women going to the US House. Under the new map, we have 4 women. Obviously, still room to improve, but that's a big change from year to year. And in addition, one other thing I want to mention is that after this decision in Pennsylvania, a very similar lawsuit was filed in North Carolina in state court, using many of the same legal theories and expert witnesses and so on. They also prevailed. And this was that map that Seth had shown in the slide. The guy said, we made it 10 Republican to 3 Democrat because we couldn't figure out how to make it 11-2. Well, this also resulted in a fairer map there. There was a net change of 4 seats in PA and 2 seats in North Carolina. So that's a total of 6 seats, which is actually 12 seats, because if you add 1 Democrat and take away 1 Republican, that's 2 seats changing hands. So these cases actually changed the net seats in the 2020 US House elections by 12 votes in favor of one party, and a race that, and the Democrats ended up with an 11-seat majority in the US House after 2020. So if not for the Pennsylvania Supreme Court's decision and the decision of the North Carolina court in the follow-on case, Kevin McCarthy would be the Speaker of the House right now. So these cases, it's amazing the echoes from a courtroom in 2018 in Harrisburg getting heard in Washington D.C. today.
Thank you.
So this is going to be. Am I out of time?
You're a little bit out of time then.
All right.
But I'll let you wrap up.
So all I would say to remain is that those are the big issues to watch out for this year, and to let your members of the House and the Senate of Pennsylvania know, and your governor know, that you want fair maps drawn without partisan factors or other unfair considerations being taken into account.
Thank you, Ben. And just to show how wide a breadth this topic can become, our next speaker, Carrie, will touch base on prison gerrymandering. And Carrie, the floor is yours.
Do you want me to?
Carrie, sorry.
Yes, Karen McCullen. Rory, if you wanted to go before me, I know you were going to lay out in a lot of detail the issue that we're talking about.
Sure, I'll go first. We have a split presentation. Thanks for having us. So my part of that split presentation is going to be looking and quantifying exactly how much prison gerrymandering is affecting Pennsylvania State House representation using the imprecise districts after the court battles over the State House that Ben mentioned. I just also want to acknowledge my co-author, Brianna Remster, who was the one who first inspired us to go on this journey of trying to quantify exactly how much prison gerrymandering is affecting state level representation. All right, let's see how we can do 10 minutes for this. So this is what we think. This is what our first panelist kind of described as the goal of it. But what if some of these people are incarcerated? And in particular, what if some of these people are only incarcerated in one of the 2 districts? And it turns out that the census counts incarcerated individuals as living where they are incarcerated. And most states and localities use that census data without any changes when drawing their local legislative boundaries. What that does is it politically advantages a district that had a prison built in that area. And prisons are generally located in rural or previously rural, now suburban areas that are predominantly white. And our incarcerated population are disproportionately non-white. So what this means is that it's easier for people who live in a district with a prison to get their concerns heard by a legislator, because the district contains what Dr. Remster and I and others call phantom constituents. If you're incarcerated in rural Pennsylvania, but you come from Philadelphia or Pittsburgh or the suburbs of either of those cities, you don't reach out to the legislator who represents rural Pennsylvania. You reach out to your legislator back home, right? Your concerns aren't just your own in your prison or your jail, but also about where your kids' education, your family's job security, things like that. And in fact, as we'll look at, the Pennsylvania Supreme Court has determined that plus or minus 5% of the average is the definition of one person, one vote for the size of state legislative districts. So in reality, if we think about this, though those orange incarcerated people are in District A, and that's why this looks like equal representation. If we think about what it really means, this is what the real experience is. District A is underpopulated. District B, where those incarcerated people came from, is overpopulated in terms of representation, because those incarcerated people and the legislators who nominally represent them in a rural district don't think of themselves as members of that constituency. So the urban and inner ring suburb districts are losing representation to rural districts by this argument. Residents of districts with high incarceration rates are politically silenced because it's harder for those residents to get their concerns heard by their legislator, because that legislator is overworked. And we've actually spoken to legislators who have said, yeah, we get letters from prisons that we have to respond to. And they're doing double duty. Importantly, it's not just a problem for the people who are incarcerated or even for their families, but for anyone who lives in that hypothetical District B is being affected by this misapportionment of people. Regardless of if you've ever been incarcerated, if you're in that district, you are experiencing less representation than you would without prison gerrymandering. So this is what some states have already done, some localities have already done that we can talk about later. It just requires a little bit of extra work by the state when districting to think consciously about where incarcerated people should be counted. But this is one thing to think about in the abstract. It's a little bit easier to wrap your head around by looking at some actual maps. So here's District 150. I drew in the black lines that you hopefully can see to show you just where the boundary between District 150 and its neighboring district is. Near the top, you can see that is SCI Graterford, now SCI Phoenix. You can also see the Montgomery County Jail down near Eagleville as well. This is one of the kind of most extreme examples, as we'll show a little bit later. Right, the rest of District 150 is largely white and largely suburban and partially rural. This, to get us even closer to home, outside of Montgomery County and into Philadelphia itself, this is, again, census map looking at the Philadelphia jail at State Road in 2010, and the District 173, which is kind of a very funky shape, I'll say. The upper left quadrant is in a different district. So we can see that being incarcerated, and it is correct that if you are incarcerated for, in Pennsylvania and have been convicted of a felony, you cannot vote, but you are still legally supposed to be represented. So the question is, how much does this really matter? And the reality is, before mass incarceration came into its own in the 1990s and into the 2000s, its effect was relatively small. But now that we've created a mature form of mass incarceration, and while we're no longer at the peak we were, it is still high enough that it would have a significant effect. We wanted to look at how much it affected 2010. So here's what we did. We removed the incarcerated people from their site of incarceration, and we returned them to our best estimate of where they lived in Pennsylvania. And for the sake of time, because I have 3 minutes left, I won't go into exactly how we do that, but we knew their home county, we knew their race, and we estimated their educational level, and we matched them to census blocks in their home counties, right? And again, equal representation is the total population of Pennsylvania divided by 203, which for 2010 was between 59,500 and 65,700. So this is the map of Pennsylvania. You can't really tell what's going on in the Philly region because it's too small in this map, but you can see that there's a lot of districts that are losing more losing or gaining over 837 residents, which is a pretty sizable amount when you consider how few people vote in state house elections often. Right, the Black districts are ones where residents are being taken away through prison gerrymandering, and the districts with grids on them are areas where a prison or a jail is increasing the number of people in that area artificially. But let's zoom in on our local area. Right, and here you can see there's District 150 in Montgomery County. There's District 173 with Philadelphia's jail. And the Black districts, there are actually 3 in Philadelphia County itself. 2 of them are contiguous, so it's not clear that there are 3. Keeping in mind, and the Delaware County, this is where Chester County's jail and SCI Chester are. Overall, of the 203 legislative districts in the Pennsylvania State House, 4 would be legally too small if we were to undo prison gerrymandering. 4 other districts would be legally too large. A total of 264,000 Pennsylvania residents we argue are underrepresented because of prison gerrymandering. And in particular, unsurprisingly, considering the racialization of mass incarceration, over 100,000 Black Philadelphians in particular are underrepresented thanks to prison gerrymandering. And as I mentioned before, and this will be my last point, this doesn't just affect the people who are incarcerated. So one way to do that is to quantify the effect on the average Pennsylvanian. The average white Pennsylvanian is in a district that, if we did not have prison gerrymandering, would lose votes. That means the average white Pennsylvania lives in a district that is benefiting from prison gerrymandering. You can see, on the other hand, the significantly larger negative effect of prison gerrymandering on the average Black and Latinx Pennsylvanian. The average Black Pennsylvanian lives in a district that should have 350 more residents than it does. And so that is kind of the lay of how much prison gerrymandering is happening. And now I will turn it over to talk about kind of legal strategies about it. Thank you so much.
Thank you, Rory. And Kara, the floor is yours.
Thank you. And thank you for having me. I'm so glad to be a part of this important conversation. Is everyone able to now see my screen? Just checking. Oh, no. Try one more time. Oh, yes. I'm seeing a thumbs up, and then I'm seeing head shaking. Okay.
No.
Okay.
Yeah, it's a no.
You have to hit the share screen and then something up top.
Yep. On my end, it's showing it sharing. So maybe I will just speak if it's not sharing in general.
You have to click share screen and then the image you want. And someone has to allow you to share screen. Whoever the
Oh, maybe it's, I think I'm still getting a message that more than one person is sharing. So maybe that's it. I'm hitting share screen and.
That's a good point. Check, Rory, check, make sure that you're out.
I think he did stop. But that's okay. I can also just talk. It's not necessary to have a presentation.
Oh, there we go.
Oh, there we go.
No. No.
Okay. Is that sharing now?
Yes. Begin.
Yes, there we go.
Great.
Yes.
Okay. Sorry for the technical difficulties. You would think by now, at this point in the pandemic, there would no longer be.
No, they happen all the time.
Well, thank you again for having me. My name is Kara McClellan. I'm from the NAACP Legal Defense Fund. We're the organization founded in 1940 by Thurgood Marshall, litigated Brown v. Board, and continue to do racial justice litigation and legislative work across the country, including in the areas of education, political participation, criminal justice, and economic justice. So this issue of prison-based gerrymandering overlaps multiple issue areas that we work on. And as Professor Kramer just described in such detail, this is truly a racial justice issue, in addition to being more generally an issue for our democracy, an issue for truth and accurate data for us as a country. The dynamics are that the reality is that we're talking about a dilution of voting in urban centers that are predominantly Black and Latino, and a strengthening or overrepresentation of voting and representational power in white communities that are predominantly rural and within the state of Pennsylvania. Pennsylvania and many other states claim to meet their one person, one vote redistricting obligations that we've been speaking about by counting incarcerated people as residents of the prison facilities where they are located, despite the fact that incarcerated people often do not live in those facilities for the entire decade. The average term in Pennsylvania is 3.8 years, despite the fact that incarcerated people are not treated by legislators who represent those prison districts as their constituents. In fact, as Roy was just describing, it's actually the districts where we know people are going to return and where they still maintain family ties that representatives are actually responsive to them. And again, generally people who are incarcerated cannot vote. So I encourage people to read the op-ed of our named plaintiff in LDF's litigation in Pennsylvania that I'm about to talk about, who really lays out how this is a racial justice issue that some have compared to the 3/5 compromise because it gives extra political clout to prison districts at the expense of predominantly Black and Latinx communities where people cannot vote while they're incarcerated. There's been federal litigation on this issue. I just wanted to flag before I start talking about the state litigation that LDF has been involved in. The federal litigation has had mixed results. There was one litigation success in Florida that was not appealed, so there's not controlling appellate or circuit law on this issue. There was another initial victory in federal court in Rhode Island, but it was countered by a loss at the appellate level. And there was a federal lawsuit in Connecticut that was proceeding toward trial before a 3-judge court when it settled last year. So we don't have clear law on the issue of prison-based gerrymandering and how it relates to the principle of one person, one vote, and general equity principles and representation in federal courts. But this issue is developing in state courts. So LDF, Ballard's Bar, and our co-counsels at the Abolitionist Law Center filed a lawsuit 2 years ago in state court challenging the practice of prison-based gerrymandering in Pennsylvania under Pennsylvania Constitution. The provisions that we made 3 different arguments. 2 of the provisions have already been talked about, which is Article 1, Section 5 of the Pennsylvania Constitution, which requires that elections shall be free and equal. Again, that's the League of Women Voters lawsuit that Ben has already spoken about, established that principle, as well as Article 2, Section 16 of the Pennsylvania Constitution, which mandates that Pennsylvania senatorial and representative districts shall be as nearly equal in population as practicable to prevent dilution of the right to vote. So this is clearly dilution of the voting and representational power of people who live in districts where people that don't have presence, essentially where people are being sent to other districts to be incarcerated, as well as the people who are actually being incarcerated. It dilutes their votes as well. And then third, as if that were not enough to have 2 direct violations of the state constitution, it also is a violation of Pennsylvania statute Title 25, Section 1302A3, which actually mandates, and I'm going to quote, that no individual who is being held at a penal institution should be deemed a resident of the electoral district where the institution is located. So this is a direct violation of the statute on its face, which provides that the individual shall be deemed to reside where the individual was last registered or at the last known address. So there's 3 different state law bases for finding that the practice of prison-based gerrymandering is unconstitutional. We filed our lawsuit on behalf of the NAACP of Philadelphia and the state conference, as well as students who were voting for the first time in this election in Philadelphia and whose votes were being diluted as a result of the practice of prison-based gerrymandering. So we represented students at the University of Pennsylvania and at Temple University. And then we also represented 3 individuals, one of whom I've already talked about and recommended that you check out his op-ed, that is Salim Holbrook, as well as Abdul Latif and Terrence Lewis and Margaret Robinson. 3 of those individuals are recently returned citizens who are living in Philadelphia, but are still, for the purposes of representation, being counted as if they are still being held in a prison. They went to vote in this last election, and their vote was diluted by the fact that they themselves, their own bodies, were being miscounted. And so we are going to continue to advocate on this issue. Unfortunately, recently, the lawsuit that we filed in the Commonwealth Court was dismissed on procedural grounds. Essentially, the court held that the Legislative Reapportionment Commission, which again, Ben has already spoken about, was a required party. It's important to remember that this entity, the Legislative Reapportionment Commission, is the entity that is formed for the purpose of preparing the state's legislative redistricting plan, and it disbands immediately after the approval of a final plan. So it only exists for a very temporary amount of time during each redistricting cycle. And our position was that the state and the governor are ultimately responsible for ensuring that the state complies with state law and with the state constitution. But nonetheless, the Commonwealth Court determined that the Legislative Reapportionment Commission has to be a party to the lawsuit, which means that it has to be in existence. In other words, we have to wait until the next cycle for the LRC to be in existence again and name them explicitly as a party. So in the meantime, as we've already talked about, it's a new cycle. The LRC has just recently been formed and is beginning this process. And we've talked about the ways that we encourage people to call your representatives, to put pressure on the LRC to adopt a map, and stay engaged in this process that moves forward to ensure that the LRC adopts a map that complies with state law and state constitution, and if not, to stay engaged in the process of challenging it going forward under state laws. So there are many ways for folks to continue to be involved in this process and stay engaged. The battle continues. The last thing I'll say is I want to flag for people, again, that this does not have to be this way, that momentum is building across the country for people to adopt a different system. It is well within our power. Pennsylvania could end its practice of counting people who are incarcerated at prisons, as other states have done. I think we're up to 9 at this point, and probably likely soon 10, given recent developments. And in those states that have changed their system for counting people, just as Rory described, they go through the process of subtracting incarcerated people from the prison location and working with the Department of Corrections or other local agencies that have already in their possession this home address data, reallocating the people back to where they actually have ties, are going to return after they've served their time. The Pennsylvania Legislative Data Processing Center already does some adjustment of census data for other things, and could easily do this to ensure that people who are incarcerated are accurately counted as well. Moreover, the Census Bureau has adopted a change in the 2020 census to include correctional population data within the main redistricting data set. And this data will give redistricting officials the census counts of people in correctional facilities at the location of the facility, making it even easier to assign incarcerated people to their actual address. State Representative Joanna McClinton plans to reintroduce a bill that would end prison-based gerrymandering in Pennsylvania, but that bill has failed in the past. So it's really important that we stay engaged in the process that the LRC is engaging in, and remind our representatives that the solution is simple. Adjust census data to count incarcerated people, not where they are in prison, but at their last known home address as state law requires. The LRC can do so, and it's just a matter of having the political will to take action. Thank you so much.
Thank you, Kara. That was extremely informative. And now I would like to turn the floor over to Deborah Gross, on the issue of court gerrymandering. Floor is yours.
Okay. So you can see a theme here, right? We're relying in Pennsylvania on some final decisions issued by our Supreme Court, and that our Supreme Court has issued some final decisions recently that I'd say somewhat upset the General Assembly, which led to the General Assembly proposing a bill known as Judicial Districting Redistricting. It was known as House Bill 196. It's currently known as House Bill 38. And I'm going to now attempt to share a screen. So hold on. Okay, and I need to start my where do there's something, hold on, sorry guys. Something I need to start my, why do I not see it here? New share, got it up.
Debbie, hit the slideshow.
Yeah, I know, and I don't see it on here. There, no, new slide. Where
Yeah,
is
up
this?
on top. Up on
Yes.
top, next to animations slideshow.
It is not there. Okay, let me try to go down again. No. Why is it's not showing up on my, okay, does that work or no?
Yeah.
Yes?
We can see it, but your notes, I hope you don't have notes.
I don't have any notes, but that's weird. I don't understand what's going on, but we'll do it this way. So, okay. Difficulties are never easy. Okay, so House Bill 38. It is an interesting bill that has, again, been something that just was rushed through, and it's a bill to change the way that we vote for our appellate court judges in Pennsylvania. Currently, and as a little commercial, remember, May 18th is the primary. You need to go out to vote, but currently we elect our appellate court judges statewide, and on May 18, you will be electing one Supreme Court judge, one Superior Court judge, and 2 Commonwealth Court judges. But that's I'm detouring. This House Bill 38, which is pending out there, I will say, proposes to change the way that we vote by district for each appellate court. So we would only be voting for one Supreme Court, one Superior Court, one Commonwealth Court judge, where we reside. The state would be divided into many different districts. We would have 7 districts for our Supreme Court candidates, 15 districts for our Superior Court candidates, and 9 districts for our Commonwealth Court candidates. What happens with this bill? If it were to pass the House and Senate twice, it's proposing an amendment to the Pennsylvania Constitution, and it is not something that could be vetoed by the governor. So it would be a ballot referendum put on our at the primary or in the November elections. Hopefully I'm just giving you another detour. There's a number of ballot referendum on this May primary. Make sure you educate yourself about them. So a little bit of history about this bill. It was introduced into the House in 2019. It passed along party lines. It was somewhat dormant. There was no discussion, no hearings, no testimony, no experts, nothing. It just passed. People thought it was going to sort of just sit there. It passed in 2019 as a result of the Supreme Court's decision on the voter redistricting gerrymandering. And then in 2020, over July 4th weekend, it reappeared, and that had to do with some of the Supreme Court decisions concerning the pandemic. I will say that we're not greeted with pleasure by the General Assembly. And over the July 4th weekend, it sped through the Senate, again, without any hearing, testimony, expert opinion. It was voted out. It was published. The proposed amendment was published over the summer in newspapers. And we thought that this bill was going to come back alive after the November election, before in January and February. Fortunately, what happened was in January 2021, it appeared before the House Judiciary Committee. The House Judiciary Committee meeting, we actually had notice of it. We were able to watch it by streaming. A number of groups got together, organized, and I'll talk about that later. And it did pass out of the House Judiciary Committee by a 13-12 vote, but 2 Republican representatives who are attorneys voted against it. And that put a halt right now to this bill. But you need to understand a little bit about this bill. The alleged justification was to make sure that all the districts, were represented equally in the appellate courts, so that there was a concern that, some of the people in the middle of Pennsylvania, and for example, the representative who proposes it in Lebanon County, are not represented on our appellate courts. He emphasizes that there hasn't been a representative on our appellate courts from Lebanon County for maybe years or ever, whereas Allegheny County has a number of judges, Philadelphia County has a number of judges, and it's not a fair and accurate representation of the state. But what does this bill really do? It makes our appellate court judges, it threatens their independence. It's going to make them more concerned with responding to their particular constituency than to the rule of law. And it will disenfranchise voters because you, as a resident, for example, of Philadelphia, you will only get to vote for 1 Supreme Court judge out of 7, and it's only every 10 years if you're lucky, right? But Supreme Court judges can be up for a retention vote, and again, it would only be every 10 years. So you would not be going to the polls to vote for a Supreme Court judge in Pennsylvania too frequently. A previous Pennsylvania Supreme Court justice noted that he was concerned with judicial trades, that judges would be careful about the decisions they wrote to make sure that they weren't coming out with any decisions that they would be punished for at a later point in time, closer to their election. There are studies that show in judicial election years that judges are much more careful in the decisions that they write. And so that this would be one way of a judicial trade would be one way of remedying that concern. And most important, it really hurts the public's confidence in the courts. Money also would be a much more significant factor, which it already is in our judicial elections, but this way money would have more influence in a more tailored district, that you could have more money pouring into a tailored district than across the state. It would also, in our belief, in Pennsylvanians for Modern Courts, it would really impact the diversity of the court. We do not have a diverse appellate court. I will acknowledge that. We have 1 woman of color on our appellate court, but we do have a significant number of women on our appellate courts. We have the majority of the Superior and Commonwealth Court judges are women, and we potentially could have a majority of the Supreme Court as women after the November election. And what happens, and why I say this could be jeopardized, is that typically appellate court judges are previously lower court judges. And we went and looked at the map of lower court judges, so common pleas court judges. And the dots indicate that in those counties, which are in the middle of our state, there are fewer than 20% female common pleas court judges. So therefore, there isn't that ability for those judges to even run because they just don't exist. I mean, Lebanon County, for example, had no female common pleas court judges. Also, the concern is based on there aren't as many attorneys in the middle of the state. We have more attorneys on our east and west coast because this is where there's more complex litigation. There are law schools, there are larger firms. A lot of the attorneys and counsel in the middle of the state are really general practitioners. They don't have the same expertise in constitutional matters. And it also proves out in the fact that many of the cases that go to the appellate courts don't come from the counties in the middle of our state. So because they don't have those kinds of issues. A lot of the legal issues that arise in the middle of the state may be more breach of contract and not cases that reach a superior and Supreme Court. So here's a map. We also received some information from the AOPC and we're able to digest it that showed that the majority of the cases that go to the Superior Court come from Philadelphia and Allegheny counties. Similarly, for the Supreme Court, the majority of the cases that reach the Supreme Court come from Allegheny and Philadelphia counties. So the location where a judge is really a misleading focus of this bill, but the representatives who supported this bill were really trying to, I will say, change the way that, change the composition of the Supreme Court. There are so many problems with this bill and this proposed amendment, but one of the bigger ones is how it will be implemented. There's no discussion as to how this proposed change will be implemented. Will we be removing all of our Supreme Court judges at one time, a clean slate? If we have two Allegheny County judges, will one be allowed to have a run for retention and the other will be told you're done? Will this redistricting occur first for the Supreme Court, then for the Superior Court, then for the Commonwealth Court? There are just, there's no answer in the legislation as to how it will be implemented. The only answer is that the General Assembly shall establish the judicial districts, determine the transition of the system, establish the order of election, and determine the eligibility to seek retention. So, this is a bill that was pretty much rushed through. There were no hearings, no experts, no testimony from bar associations, from lawyers as to the impact of this. And it really is, it's frightening. I mean, there's still time for this proposed amendment to come back. It has a 2 years, so it can go through this November and through next November. So through 2022, we have the possibility of this proposed amendment being on a referendum on the ballot. I know I'm running out of time. We in Pennsylvania elect all of our judges. Our appellate court judges, we are one of 9 states that elect appellate court judges. If we would change to electing appellate court judges by district, we would be only 2 other states do this, Illinois and Louisiana. So it shows that this is clearly not a popular method. We in PMC believe that merit selection or appointment is a better method than even elections, and that's a different story for another time. But again, who supports the amendment? It was a few limited representatives who were not happy with some decisions by the Supreme Court, whereas many groups opposed the amendment. And one of the reasons why we were able to halt it recently, I can't tell you get rid of it, but halt it, is that we organized a table called Judicial Independence Project of Pennsylvania. We got many of the bar associations to write letters and to reach out to their representatives. Many good governance groups got together. We also reached out to the chambers and many legal nonprofits. And at the House Judiciary Committee hearing, Representative Briggs was able to read off the names of the many groups that opposed this bill, which also, I believe, had an impact on putting a halt to this. So what are the next steps? Hopefully this bill will not come alive, but if it does, again, we need to have you voice your opposition because it could reappear at any time in the next year and a half. So, okay, so I've sped through everything, Wes. I'll stop my share.
Great job, Debbie. Great job.
Trying to keep us on time.
Appreciate it. And with that, it would be remiss if I did not introduce Khalif Ali. He's the executive director of Common Cause Pennsylvania. Was going to be participating in our panel today, but had a little event with his son. I'm glad to hear your son is doing great. But Khalif is one of the important players in fighting for fair elections. And Khalif, please feel free to join in the next sections of the presentation. And with that, I just have a general question for everybody in the panel. And I think is really teed up by Debbie's last point. What can lawyers and others do to help in these situations? And I will throw it out to the panel, and I think I will leave it in the order that we started with, so that Debbie would actually have a chance to breathe. So Seth, would you like to take us?
But now I think this is really kind of above my pay grade. I can tell you about how to amend the U.S. Constitution, or I could talk about expanding the U.S. Supreme Court, but neither seems to be likely at this point. Let me let some people who have more useful advice proceed.
Sounds fair.
Well, I'll take a stab at that. The Legislative Reapportionment Commission is convening, is going to be holding public meetings and accepting public comment. And they are going to hear an earful from Harrisburg insiders, from lobbyists, from the political party leadership about how to, protect this guy's seat and how to knock that guy out. I don't like any of that. I mean, I think they need instead to be hearing from people about why we need fair districts, why we need districts that are about respecting local government boundaries and compactness and equipopulation, and not about helping out this guy or hurting voters from that party. So they are politicians, and they should hear from constituents, and that includes all of you.
And I'm agreeing with Ben. I mean, there are so many issues that affect us in so many different ways with respect to the courts and the districting, and and a lot of the legislators aren't even aware of why things happen, what they do, how they impact. And it was really helpful when all the groups got together and started, even lawyers didn't even know what was happening. So it's really important to educate and inform, and people should go out and vote and make sure you educate yourself when you go out and vote. But it's a lot of communication and information and speaking.
I was going to say something that the question and also asked. There are also websites that you can go to and draw your own maps. And as Ben's explanation of what happened with Amanda Holtz showed, it was people pointing out, like, this map is ridiculous, you can do better. And also, and Ben pointed out one that uses the sociological gobbledygook that John Roberts so despised, but actually I could walk you through its very simple logic and simple math. There's nothing gobbledygook about it. We can do that. And so, and if they know that people are going to pay attention, and these are the ways we're going to pay attention, then they have to react to that. Redistricting and gerrymandering has succeeded often because no one was paying attention or didn't have the fancy skills. You don't need that. There's planscore.org. If you want to just draw your own districts, districtor.org, which I'll put in the chat, is another good one for doing that. And you can send those to the LRC and say, this is important to me that these people be kept together. This is important to me that you not draw a map where a district is only valid if there's a prison in it.
And I just wanted to emphasize, because this is actually something that Rory and Brianna had to confirm for me. There is no way of redrawing maps in Pennsylvania that will address the issue of prison-based gerrymandering. It is a function of the reality of where prisons are and how mass incarceration has impacted the state, such that there's no changing of the lines. It's literally a practice of counting that violates the statute and that is undemocratic. And so I just wanted to emphasize that for people, but also as we're thinking about kind of our roles as lawyers and as citizens, I think it again goes to the very core issue of having accurate information. There's some reporting on the issue of prison-based gerrymandering that NPR did about the state of Wisconsin, talking to citizens in different districts who are looking at the data as it's reported as a result of prison-based gerrymandering and saying, this doesn't even reflect the demographics of where I live. It says that we're 80% X and actually we're 100% X, or it says that, we have, it's a function of literally, in this era where we have to be concerned about fake news and what are real facts. Prison-based gerrymandering is another issue where we need to have accurate information about what different districts look like, what their demographics are, what the socioeconomic status of people are. Basic information that we should all be concerned about is not accurately being reported because of the distortion that's going on as a result of miscounting people.
Thank you. And I gotta give it to this panel. You guys are great. I don't even get a chance to read the questions out of the chat, and you guys have already answered them and put the information in where they can go to. So that was great. For those who weren't looking at the chat, there were questions about where the commission hearings are going to be, and that was already answered in the chat, and what organizations or tools can be used by normal people to evaluate the maps. And I believe you guys nailed those questions along those lines. And with that stated, I don't see any other questions. Oops, I think Jenny just got us again. Does PA have the information it needs for the LRC to stop prison gerrymandering this time around?
Do we mean that the Commonwealth or the governor have the information? Because I think our lawsuit put them on notice.
Yeah, the lawsuit did that. Governor Wolf claimed that he asked the DOC to keep track of addresses. So for state prison incarceration, that should exist. One of the things that in the nitty gritty of our piece is state prison population is 55–60% of all of the incarcerated individuals that we reapportioned ourselves. So county jails, right? And that map of District 173 points out, county jails are also a part of this. And we don't have information about whether every county has done that. So we can mitigate the harm in 2020, 2021, using those state prisons. And other than 173, I think that would resolve all of the bad maps from the prior one. They all involved the state prison location. But we also need to tell counties for the future, you need to keep track of this because we're not letting you count them there. And to localities, Philadelphia is going to have to redistrict its council districts at some point. And Philadelphia's jail is part of that. And the Philadelphia residents who are being incarcerated elsewhere in the state could conceivably be part of that redistricting as well. But Philadelphia doesn't have a local prison redistricting issue, prison gerrymandering issue as well. So we need to deal with that. Yeah.
I'd add just one more thing to that, which is that we also don't have data for federal inmates. The Federal Bureau of Prisons doesn't provide that information. The gold standard fix for this, and it's too late to do it for this cycle, but it's not too late to fix it for the 2030 census, would be for Census Bureau to redefine the rule for residency for inmates, to set it as their home address instead of their cell. And in fact, HR 1, the big omnibus voting rights bill that's pending in the US House, would do just that. It would require the Census Bureau to count inmates at their home addresses. Alternatively, the Department of Commerce could promulgate rules through notice and comment process for the 2030 census that would redefine residence for inmates. So that would be the best way to fix it all over the country in one fell swoop. But short of that, there are these other important tools that we could use to mitigate the problem in PA.
All right. Well, thank you very much. I'm going to be very respectful of everyone's time because you guys have literally been perfect down the line. So I wanted to thank the panel. I wanted to thank you for all you guys did. Put together a great amount of information for for us, and thank you for all that you've done. And I also wanted to take this opportunity to let you know that our next program for the Philadelphia Bar Association will be the virtual spring quarterly, featuring the future of the work after COVID-19 and featuring Peter Capelli and a bunch of different panels of bar leaders from the Philadelphia legal community. So with that, I will thank you all and say a good night. And thanks again to the panel for doing a great job. You guys were outstanding. Bye-bye.